We want to talk with you about domestic violence protective orders. These are often called restraining orders. We also want to talk about planning for the safety of you and your children. A court can grant a domestic violence protective order when another person has committed a crime of violence against you or has threatened you with violence. The court will order the other person to stay away from you.
A protective order, for the most part, reduces contact between parties or can eliminate contact between parties. The idea is that it will prevent the opportunities for continued violence between usually two people.
To get a protective order, the law requires that you have had a particular kind of relationship with the other person. The person can be a current or former spouse, a current or former boyfriend or girlfriend, a current or former roommate, or a family member. If you don't have this type of relationship, you may be able to get another type of protective order, such as for stalking or sexual assault. We will not discuss these other orders in this video. Along with the particular relationship, the person must have committed a crime of domestic violence against you. You can get a protective order on behalf of your children if the other person has committed a crime of violence against them. The most common reason to get a protective order is assault, but there is a long list of other crimes of domestic violence. You don't have to state the name of the crime, just describe what happened. The judge will figure out if a crime occurred. A crime may have occurred even if you were not physically hurt, but only scared that you would be hurt. You may also describe past violence and why you need protection now.
The things that a judge needs to be informed in deciding whether or not to issue a domestic violence order is exactly what happened. Domestic violence is classified as a criminal conduct, but the victim need not put a label on the actual conduct. It's only describe the conduct in as much detail as possible as to what exactly happened.
What I'm looking for is some evidence that the crime has already been committed. A lot of crimes of domestic violence happen in the privacy of someone's home or without other witnesses involved. But there is frequently some evidence that could be brought in. What I've seen is, the torn clothing, the messages on the answering machine, the cell phone records, that kind of thing that helps shore up somebody's testimony in court.
So any piece of evidence, let the judge decide how important the evidence is. The important thing for the victim to do is to bring the evidence before the court.
Don't worry if you don't have any physical evidence to bring to the court. You can tell the court what happened. A protective order can order the respondent to stay away and not contact you even by phone, email, letter, or through friends. Or it can allow for some limited contact if you, as the petitioner, request it. It can give you the use of the house and the car. It can give you temporary custody of the children. It can provide for child support. It can provide for financial support. It can provide for a police escort to allow you or the respondent to pick up personal belongings or documents. Once you have a protective order, it is a crime for the other person to violate the no contact parts of the order. That means the other person can be arrested.
When a court order is issued, a domestic violence order, and the perpetrator has been served. That order is very specific. No contact with the victim, either direct contact or indirect contact. No telephonic contact, no correspondence contact, no contact through friends. Oftentimes, a friend is used to try to influence the victim in a certain way or to convey messages. That is inappropriate conduct. As soon as the victim, because the victim has to copy the order also. So if an act is done by the perpetrator that's contrary to that order, the victim should immediately call the police.
To get a protective order, most people begin by filling out a petition. You can get the petition from the local courthouse, a shelter, or the court system's website. The petitioner is the person who asks for the order. The respondent is the person whom the order is against. The two most common kinds of protective orders you can request are ex parte orders and long-term orders. A petitioner can ask the court for an ex parte order without telling the respondent beforehand. When the order is granted, the police will deliver it to the respondent. In the same petition, you can also ask for the long-term order for 1 year. If there is no emergency, you can apply for the 1-year order without asking for the ex parte order. The ex parte order is effective as soon as the judge signs it. However, the respondent cannot be arrested and charged with a violation of the order until it has been served or delivered by the police.
When a petitioner fills out the application for a protective order, they also fill out a piece of paper called Directions for Service, and that is the information on how to find the respondent or the abuser so that the police can serve them. We need as much information as we can get. The problem is if they only put down the home address and the order is kicking the person out of their home, the police won't find them. So we need them to find the person. Any information they can provide, that is friends, family members, message phone numbers, a workplace, anything at all that might help the police to find the person would expedite getting that order served.
The ex parte order also sets a date for another hearing for the long-term order if you have requested one. The respondent has to receive notice of this hearing so that the court can listen to both of you. You, as the petitioner, must appear, or the case will be dismissed. If the other person, the respondent, doesn't appear, the court will hear the case based only on what the petitioner says. To prepare for a protective order hearing, you need to think about 2 areas. First, figure out how to present your case that the respondent committed a crime of domestic violence against you. Plan what you will say and decide whether you have any evidence or witnesses to present. Second, if you have children with the respondent, think about what temporary custody and visitation plans you want the court to order. The court can order temporary custody of the children and a visitation plan for the respondent if the visits can occur safely. These provisions last for the length of the protective order.
So what I would most like to urge is that when people are coming to court asking for orders related to the children, that they think about all the provisions that they need in place to make it safe both for themselves and for their children.
Some things to think about with visitation planning are: do you want to have a specific schedule for visits? Do you want visits to be supervised by someone you approve of and who is willing and able to supervise? Do you want to let the respondent have overnight visits? Do you want the respondent only to have visits in a public place? Do you want the respondent not to drink or do drugs around the children? Do you want the respondent to have visits only if he or she is going to alcohol or drug treatment? Do you want to prohibit all visits? Remember, even if you don't want the respondent to have any visits, you should also be prepared with an alternative plan in case the judge decides that visits will take place. It is very important to tell the judge if you have any other court cases going on, such as a divorce, custody, child in need of aid, or a criminal case.
Not only is it important to mention your other cases, it is required.
The judge can order the respondent to pay child support. If possible, before the long-term hearing, find out how much money the other person makes. Also, bring financial documents to court, such as pay stubs and tax returns, if you have them.
So if the wife or the victim of domestic violence has any evidence to present to the court as to what the income of the perpetrator is, that victim should bring that evidence forward, because the court will need to know, to be informed as to what range of income the perpetrator has.
You must take responsibility in enforcing the protective order. If the respondent violates the order, call the police, the state troopers, or the village public safety officer. For some violations, like threatening you or contacting you, the person can be arrested. For others, like not paying child support, you need to go back to court for help.
A protective order is a piece of paper. It is not a bulletproof vest or a shield. So it is only as good as the ability to enforce it. If a person is willing and able to call the police when there's a violation, then the police can respond and they can enforce the order.
There are some things you can do to plan for your safety. Have a list of phone numbers in case you have to leave quickly. Know the fastest way out of your house. Have keys, medications, and documents ready in case you need to leave quickly. Have a code word with trusted people for when you need help. Have some cash and your own credit card available.
She should make arrangements also for her own financial well-being, because oftentimes a victim of domestic violence relies primarily on the income of the perpetrator. So a victim is victimized many times over. It's not only the physical act that's committed to the victim, but oftentimes for at least that interim time, she loses the support of the perpetrator.
We want to emphasize how important it is that you plan for your safety. Leaving an abuser can be dangerous, and even with a protective order, you need to think carefully about your safety. A long-term order lasts only for a year. When the order expires, the custody provisions will no longer be in force, and both parents will have access to the children. You can go back to court and get another order if you are still in danger. But for the long-term safety of you and your children, you may want to think about a divorce case if you are married to the respondent, or a custody case if you are not married but do have children together.
If the victim feels that the relationship is gone, is no longer a healthy relationship for the victim to be in, then the next step that she needs to take is a divorce petition to get a divorce and a final order of custody, a final order of support, a final order of the division of the marital estate.
A divorce case will end the marriage, decide child custody, and divide property and debt. A custody case will decide child custody, visitation plans, and child support. There are other important legal issues to consider in getting a protective order. For example, a protective order may prohibit you from leaving the state without permission from the court or opposing party. It can also affect custody provisions in future divorce or custody cases. If possible, talk to an attorney to decide whether a protective order is the best course of action for your situation. You can get a protective order even if you are not a U.S. citizen. You will not be deported if you apply for an order in state court. The Alaska Immigration Justice Project may be able to assist you. If you are in a village or a rural community, there are other things to think about. You may not live near a courthouse. You can download the form from the internet, call the nearest courthouse to have it mailed to you, or get it from the nearest shelter. You don't have to go to the courthouse to file or for the hearing. You can fax the forms to the court and ask for a telephonic hearing. Your safety is the most important concern. Law enforcement may not be present to quickly help when a protective order is violated. Think about how the other person may react when the protective order is delivered. Have a safety plan in place. An advocate from the nearest shelter can help you to leave your village if you think it's necessary for your safety.
A lot of people, a lot of victims are intimidated by a system. This is a huge courthouse we have here. Very formal courtrooms. A person that sits behind the bench wears a black robe as a sign of authority. People are intimidated by that. A lot of people that have never dealt with the court system are intimidated by it. A lot of them are not very articulate. And they hesitate to seek protection because they feel embarrassed.
You can get help. Domestic violence shelters have advocates who can help you with planning and support you when you go to court.
The role of the advocate is to assist that victim, to give them a comfort zone, to explain basically that this system is designed to protect the victim and not to be intimidated by the system.
An advocate can also help find housing, food, and counseling for the victim and the children. She may be able to help with finding legal assistance. For help, you can contact a shelter in your community or call 1-800-799-SAFE. That's 1-800-799-7233. You can also call the Alaska Bar Association for attorney referrals. If you are low income, Alaska Legal Services may be able to provide legal assistance in certain situations. If you need to represent yourself, you can get legal information and forms through the court's Family Law Self-Help Center. The Family Law Self-Help Center has a telephone helpline and a web page. You can speak one-on-one with a facilitator. You can learn how to prepare for hearings. The service is free. We have only talked about the main considerations for domestic violence protective orders. Court System Publication 22 contains more information about these orders and about how to represent yourself. Try to make your decisions and proceed through the court process without exposing the children to the process, if at all possible. These are adult decisions. Children need to be protected and not drawn further into the arguments. We want to emphasize again, protective orders can add to your safety, but a protective order is only the first step in planning for your future and for your children's future. You need to make long-term plans that will keep you safe.